Greetings, dear colleagues, candidate, and the public. Today, on the 19th of January 2025, the advisory group of experts met to interview the candidate for the position of judge of the CCU, Mylovanov Ruslan Valeryevich. In particular, all AGE members are in attendance. AGE Secretary, Madam Maureen O'Connor, AGE members, Mr. Vasil Shakun, Yaroslav Romanyuk, Alesh Zaler, Hanna Sukotska, and myself, AGE Chair Oksana Vasilchenko. During the interview, we have AGE deputy members Vitaly Makhinchuk, Vladimir Kuzmenko, Marek Zubik, Richard Barrett. I'd like to know that we are working in a shelter, so in the event of an error alert, interviews will be continued without interruptions. I'll also remind you that the interview is recorded and broadcast live on the AGE web resources and on the CCU website. I remind AGE members and the candidate that using sensitive data and restricted information must be limited while on the live broadcast. Should there be a need to discuss such questions, the AGE will pause the broadcast for that period. We are ready to start, so I pass the floor to AGE Secretary Madam Maureen O'Connor to briefly introduce the candidate and to remind the rules of procedure for the interview. Madam Maureen, the floor is yours.
Thank you, Madam Chair. Good afternoon, ladies and gentlemen, the members of the public that are watching, as well as our applicant. As our chair has said, the advisory group of experts will now interview the candidate Ruslan Mylovanov. I'm sorry, my pronunciation. I hereby recall that the interview, that the opportunity to interview is an option that is mandatory to be presented in the assessment of candidates with the assessment of their compliance with the criterion of high moral qualities. The time allocated for the interview is approximately 1 hour, and the time limit for answering a question is up to no longer than 3 minutes. As always, we ask that each candidate to be concise and provide answers that are clear, unambiguous, and to the point. At the end of the interview, the candidate may make brief final remarks, no longer than 5 minutes. I would like to point out that in the course of the processing materials about the candidate, the AGE has sent him questions to provide written explanations, so the candidate has the opportunity to prepare and to provide those answers. So now, here's the candidate for the position of judge of the Constitutional Court of Ukraine, Ruslan Mylovanov. Yes. Whom the Selection Commission under the President of Ukraine has admitted to the competitive selection. For the last 15 years, the applicant has been practicing law in criminal, administrative, and civil cases. He also has been has working experience in internal affairs agencies as he served there between 1993 and 2009. Mr. Mylovanov, this is the hardest name. Okay. If you'd like to add something to the introduction that I have made, any additional facts that you'd like to present about your experience or your background, you may have up to 3 minutes to do that now.
Дякую.
Thank you. I think the information has been provided in full.
Колеги, прошу задавати.
Colleagues, please ask questions. Mr. Alish.
Yes, thank you, Oksana. Good afternoon, Mr. Mylovanov. I have the first set of questions which relate to your practice of law. Namely, you are practicing law under the Certificate of the Rights to Practice the Law, issued based on the decision of the Poltava Regional Qualification and Disciplinary Commission of the Bar dated November 2009. Could you explain us what kind of attorney services do you provide?
The I provide the following services, and that is protection against the criminal liability. Well, not liability, but blame. I also provide to prepare the lawsuits when filing a civil lawsuit, and I provide consultations on different legal matters to the citizens.
I see. Could you explain us why did you not indicate that you are a member of the National Bar Association in your declarations for 2022 and 2023?
Since I am no declarant in the understanding of the NACP, I filled in the declaration as a mandatory document for the participation in the competition. And back then, indeed, I did not approach carefully the rules for filling out the declaration correctly, and so I made certain inconsistencies. And I did not do that trying to deceive the supervisory board or the commission, but the mistakes were made due to very little experience of filling in such declaration. So in the future, when I fill in the declaration for 2024, when I filled in the declaration 2024 and submitting it by the 1st of May, all these flaws will be eliminated, especially those flaws that were brought to my attention by the AGE.
We are in particularly interested to clarify the issue of your income from your activity as an attorney. You earn any income based on this activity?
In my explanations to the AGE, for many times I have indicated that I am convinced that the income itself, if to see it as a profit, I did not obtain. Yes, the clients did pay certain funds for me to fulfill their inquiries or orders, and I used them to prepare for the sessions for transportation, since I have many courts hearings, and lots of them are located far away from my place of residence, so I had to sometimes use more than two means of transport to get there, and also preparing the procedural documents for persons, and I had to use paper to do so, some printer, and if exclude the obtained from the customer income, no profit left. That's why these funds I did not declare.
You have been actively providing legal assistance for the last 15 years as a lawyer, and in particular provided the advisory group with an extract from the Judiciary of Ukraine website, according to which since 2015 you have been involved in about 100 court cases as a legal representative. But still, you claim you have not received and do not receive any income. Do you think that this is a convincing explanation in 100 cases and no income and no declaration of income?
As for 100 cases, in the opinion of experts, I can explain the following. I have provided the abstracts from the site, the website, from the Judiciary of Ukraine website, where the cases were considered by the Poltava Courts of Appeal and Krukivsky. And if we take into consideration that many cases have passed the first instance court, then the appeal, then the cassation, then then the case would go back to courts of appeal again, and after the appellate consideration would go back to the first instance court, and then again to courts of appeal. So many cases are ongoing for 5 to 8 years, and for this period of time the case passes 2 or 3 times the appellate institution. So if I exclude these cases, there will be a lot less of them. That's all.
We are speaking about 15 years and 100 cases and no income. Do you think that a reasonable outside observer would believe this?
Well, if to apply the criteria of impeccable attitude, then yes, the regular citizen may have doubts in my explanations, but I for many times have explained that the cases are lasting for years, and if I take into consideration that I got 2,000 hryvnias from the relatives of the person who who was a defendant, then if you desegregate 2,000 hryvnias per 2 years, then you can get 250 hryvnias a month, a year even. And if I also extract expenses on transportation, paper, and all the other things, then in fact it's around zero or maybe even less than that, and that is the income, zero income. So the outside observer may have some doubts, but I have provided my explanation that is based on my internal beliefs and nothing else I can add.
Okay. I will ask the next question. The Unified State Register of Court Decisions contains a case over the recovery of a debt of 225,000 Ukrainian hryvnias under the legal aid contract at the request of the advisory group. The Autozavodsky District Court of the city of Kremenchuk provided a copy of the contract you have entered into with your client in this case, when you indicated in your own hand 10,000 Ukrainian hryvnias as your monthly fee. How would you explain such circumstance?
Yes, indeed, there was a case when I have concluded the contract with one citizen. I'm not gonna name his name. In that agreement, it was specified that indeed I will be providing the legal guidance on all of his cases, enterprises where he stands as the founder, and will also provide the legal support to his relatives. According to this agreement, I provided assistance to his wife, his mother, and him in person for many times in administrative, civil, and a few even criminal cases. And also a big volume of work was done on servicing the enterprises where he was as the founder. And mainly I was developing the drafts of agreements with enterprises who contacted these enterprises. And I got the notary power of attorney by the directors of the enterprises where he also was a founder. So in fact, I have done a volume of work with a grounded expectation that I will get the corresponding pay for this. But this citizen try to circumvent, to avoid paying this money. So further on, I had to file a claim, a lawsuit to the court. But since in the lawsuit the conditions of the agreement was described incorrectly, and also the first instance court has denied me satisfying this claim, and then I also have applied to the courts of appeal. That was also rejected, and the cassation complaint. But the cassation proceeding was not open, since the cost of the lawsuit was not sufficient to open the cassation proceeding. So on this contract, on this agreement, I got no funds. Yes, indeed, this person maybe did allocate me 1,000 hryvnias for transportations once or twice a year, because the location of the enterprise where their activity was based and where I had the office allocated, it was far away from my place of residence. In order to get there, I had to use two means of transport. So, in fact, I spent that money on transport, and I even had to spend my own money. So, as for this agreement, no material funds I got from it.
You use the standard contracts by which you provide legal services, and if you provide them for free, being only reimbursed for actual costs incurred, then why do you separately include in the contract the amount of your fee and travel expenses, and prescribed there the fee payment procedure?
In my explanations to the AGE, I have specified that this sample of contract I got from the internet resources. And indeed, I did not adjust it in line with my requirements or conditions, but I used it just to make the relations with the client legal. As a lawyer, issuing the order in the court, providing also bearing responsibility for concluding an agreement, being able to represent the interests of the person in the court. If you take a look at the sample, it's a one-page A4 contract, and there are only two conditions listed, but that you have just also articulated. So I'm just explaining that this type of contract I borrowed from internet and I used it for my activity. No, it did not bear any liabilities, and actually that backfired at me when I tried to collect funds from my client for the work that I did for him.
So you're using the wording of the contracts which does not reflect the real agreement with the parties. Do you consider this as a professional, a diligent approach of a lawyer?
I would like to draw your attention that the workplace is my place of residence. I don't have any office, I do not rent any office. So, in fact, I was providing assistance to my acquaintances and acquaintances of my acquaintances. So, I was inattentive during conclusion of the agreement because, yes, really, in the agreement it is necessary to specify rights and duties of the parties. My duty to provide legal aid was specified, but unfortunately, I did not pay enough attention to the duty of the person to pay for the services because the first result was not to get super profits. I was obtaining experience as while working in law enforcement bodies. I faced more the practice of preparing reports on administrative offenses and investigation of criminal cases. My knowledge in other spheres.
My question is that the following: your legal aid contracts provide for paying the fee, and it's quite clear it requires that the fee must be paid on the day when the contract is signed, which is actually a normal, standard practice of lawyers. Now, how can this provision be reconciled with your explanation that you provide legal aid for free?
If we attentively look at all the provisions of the agreement, at the end of the agreement it was specified payment and expenses, travel expenses. So there is no word honorarium or fee. I did not use this word. Sometimes 500, sometimes 100, 1,500 hryvnias were specified there. I considered the scope of work that I could provide for the person, and I thought approximately how many personal resources I would spend to go to these hearings, what would be my expenses on drafting of procedural documents, copying of respective attachments. So the agreement did not specify the amount of the fee.
Yes, you already said several times that everything is covered by the costs, which for me looks rather unrealistic. But um, what is the purpose of your practice of law if it brings you no profit? What is the purpose then?
The key purpose when I started engaging in the practice of law was to obtain respective knowledge. Yes, of course. For over 5 years at the website of WorkUA, my CV is there. So I tried to find work as a lawyer, as a head of the Economic Security Service. Over these 6 or 7 years, I had 2 offers. So, in fact, I was doing that in order to obtain sufficient experience as a lawyer, and further on, while being employed, I would like to use it in my further activities. The fact that this work has not been found until now, that's not my mistake. I think that some employers are scared by my experience of working in law enforcement bodies. I have faced that several times. So that is why I'm not saying that I work to the detriment, but I almost work at a zero level.
Question is the following. The law of Ukraine on the bar and practice of law provides that an advocate may practice law either individually or under the business legal structure of a law office funded by a single advocate or law firm funded by two or more advocates. And my question is, in what form do you practice law? Individually or under the business legal structure?
I perform my activity individually. So that is why the place of my work is specified as my place of residence.
Within the meaning of Part 1 of Article 13 of Law of Ukraine on the bar and practice of law, an advocate practicing law as an individual practitioner is a self-employed person, and according to Article 178.1 of the Tax Code of Ukraine, persons intending to practice individual professional activity must register with controlling bodies at their place of permanent residence as self-employed persons and obtain a registration certificate. So, are you registered with the controlling bodies as a self-employed person? And if you are, what's your registration date?
Previously, I was not registered as a self employed person. As of the moment of the start of 2025, I got registered as a self employed person.
You registered 2 weeks ago. Am I correct?
Yes.
Okay. Do you consider this as compliant with the applicable laws of Ukraine?
Um, you can answer differently in this to this question, but I will answer directly. At the beginning of my activity, my goal was to obtain experience and not income. I thought that if cases would go well, if I have many clients, if I have some offers, then I would be registered and then I would pay taxes from income. So it happened like that. Subsequently, while talking to the AGE, I revised this issue, rethought it, and yes, in order to avoid any doubts about my competence and integrity, I decided to get registered, and further on, I will declare respective income if I have such income, and I will pay respective taxes from them.
Well, let me summarize. In 15 years of practicing law, you have not been registered as a self-employed person or as a sole proprietor, and accordingly, neither have submitted any report or declaration on your activities, nor you have paid taxes. Correct?
Yes, really. I was not registered. I did not submit reports. I did not pay taxes, as I did not have income from this activity.
Now let me ask you the following, because you indicate that you have received certain money from your clients, but you do not regard it as an income. However, according to paragraph 2 of Article 178.3 of the Tax Code of Ukraine, in the event that the person fails to obtain a certificate of their registration as a person conducting independent professional activities, the taxable item shall be income received from such activities without any deduction of expenses. Therefore, not only your not that not only your not profit, but also the expenses you incurred with respect to the case proceedings were subject to taxation. Do you understand this?
I cannot but agree with provisions of the law, but it is my internal conviction that if the person gets income, then it is necessary to pay taxes from this income and not from this gross profit, for example, like in an enterprise. Enterprises also get some gross profit, then they deduct expenses for manufacture, other expenses for labor resources, etc. And then they pay taxes from the remaining amount. This is my internal conviction.
So your internal conviction is above the law. Oh, thank you. I have no further questions, and I will pass the floor to my colleague, Mr. Vasil Chakun, to continue posing some additional questions.
You have mentioned that you served in internal affairs bodies at the position of the investigator of the unit of Kremenchuk City Department and and resigned from internal affairs bodies, and since then you receive pension from the state. Can you please tell us, uh, did you pass through the commission before your resignation? Yes, I passed through the military medical commission in Poltava region. It's not military medical commission as such, but its abbreviation contains this phrase. I passed it in 2009 before my resignation. How many years of experience did you have back then? I served for 18 years and 4 months, if I'm not mistaken. In the beneficial definition, it was 20 years and 6 months. Okay, clear. So, according to your previous explanations, there is such an impression that the main source of income right now is your pension from the state. Yes. I would not want to ask about the amount of this pension, but I forecast that this is not a huge amount. The AGE has received from me at the pension site of Ukraine, there is the electronic account. I requested through this electronic account the expert regarding my the amount of my pension. The AGE has all of these data of 15 years. Right now, my pension, once I increased it, unfortunately through a court decision, I believe that it is sufficient. If we compare that most retired people in Ukraine have the pension of about 2,800, 3,200 hryvnias, my pension is 5 or even more times more than this level. So I believe that this is sufficient for living. Yes, you cannot have a luxurious lifestyle using this pension, but with frugal lifestyle, it is enough for our family. Okay, I understand. Now, I have some questions about your property. According to information that you provided in the declaration for 2023, since September 14 of 2012, you have been the owner of a residential house with a total area of 108.5 square meters. In your declaration for 2022, submitted on December 29 of 2023, and in your declaration for 2023, submitted on March 27, 2024, you indicated that the value of the house was 188,191 hryvnias. While in your declaration for 2023, submitted on last year, you indicated that this value was 280,700 hryvnias. At the same time, the amount of funds you paid under the sale and purchase agreement as of July 12 of 2012 and February 8 of 2013 amounted to 274,288 hryvnias. So, what was the real price of this house? With respect to the information I provided in the declaration, I would like to explain the following. The amount of 180,000 hryvnias was specified by me based on independent expert valuation, which was carried out during the preparation of documents for conclusion of the sale and purchase agreement. This amount is also specified in the sale and purchase agreement. So, during submission of the first declaration, I took this particular amount as the basis. Then, further on, while submitting the clarified declaration, I specified this amount of 280,000 hryvnias. This amount consisted of the amount from the value of the house, which I paid while signing the sale and purchase agreement, and notary services, that is about 6,000 hryvnias. So if we add up, then the value of the house that I pay for the house, then we have this amount of 280,000 hryvnias. This difference emerged due to different criteria for valuation of the price of the house. So one was specified in the expert's opinion, and the other one consisted of expenses on the purchase of the house and notary services. What do you think? Can an external observer have such an impression that you intentionally lowered the value of the house in order to pay lower taxes? And then you could increase it as you did. I will explain that I paid taxes from the amount that is specified in the sale and purchase agreement and not from this 180,000. If I specified the amount that was specified in the independent expert's opinion, and that figure would be included into the agreement, that I would have agreed with you that maybe this value was specified to lower the taxes. But I would like to draw attention to the fact that I specified the real value, because as a lawyer I realized that in case of any reasons for the recognition of this agreement as invalid, I would be repaid the amount from the sale and purchase agreement. So in order to safeguard myself in the future, I specified the real value and I paid taxes for it. The sale and purchase agreement clearly states that the buyer pays all the taxes. In the declaration, you specified that since September 14 of 2012, you have had the right of ownership for 108.5 square meters of the house, while according to the sale and purchase agreement dated July 12 of 2012, you owned only 9/10 of this house. I am explaining. As of the moment of the purchase of the house, there were valid restrictions regarding the sale of the house if it is located on the areas without cadastre numbers. Since the cadastre number for the land plot was not assigned, it was not privatized. Upon the recommendation of the notary, the transaction was performed in 2 transactions. So preliminary, the sale and purchase agreement for 9/10 of the house was concluded, and then in 2013, when respective electric registers started functioning, in order not to re-register and not to take the certificate from the construction bureau, 1/10 of the house was registered before the start of 2013. You did not receive income for your practice of law, and you did not have a very large pension then. What sources of funds were used to purchase this house? I'm explaining. I have provided my explanations to the AGE as well, and I will explain again. Approximately in 1997, my wife and I privatized 1-room apartment. After its sale, there were respective funds, and the 3-room apartment was bought with a small additional payment, since 1-room apartment was located in a newly constructed building and its price was much higher, and the 3-room apartment was located in an old panel building, and
Our family was getting bigger, so we needed enlargements. When we were selling the 3-bedroom apartment, and I would like to draw your attention that in the spring in 2012, me and my wife have sold this 3-bedroom apartment with amount of approximately 32,000 USD equivalent, and it if we exchange this amount in USD at that period of time, I have provided the explanation that after being dismissed in 2009, I had the right for one-time pay for dismissal for 18 calendar years, and I got this amount, and it was in total 2,000 USD. Unfortunately, I don't have the receipt for the exchange rate operations, but this additional pay was this amount. I did provide the origin, the copy of the origin from the order on my dismissal. If we uh, sum up all these amounts that you have just listed, and the advisory group of experts, the ones that we have, this money is not enough to purchase this house. And that is without considering also the expenditures you incurred during the documenting all the papers and repairs. And how can you explain this? Why do you say that it's not enough? If we assume that with $32,000 we sold it and then added $2,000 more that I had from my savings, it equals $34,000. You did not show your savings here anywhere. Back then, I was not I did not subject to declaring, so I did not have the duty to declare it. Well, you also have a car, as far as I understand, right? The Volkswagen Passat. Given your altruism when providing your services, legal services, this car, Volkswagen Passat, produced in 2001, worth 100,000 hryvnias. So does the amount you indicated of 100,000 hryvnias paid for acquiring this car correspond to the facts? If yes, then in what way was it generated? Yes, this amount is true. And I would like to draw your attention that this car is produced in 2001. I understand it. So this car is over 20 years. For the address of the AGE, I have sent the documents that I was provided by the owner, the previous owner of the car, on the purchase of this car in Poland. And there he indicated 4,000 zloty. So back then there was zero customs clearance, and invested 50,000 hryvnias, and that's how we got 100,000. This car had some damage of the lights, rear lights, and I think that this is the average price of this kind of car. Of course, there could be fluctuations in prices for this Volkswagen Passat with $2,000 to $4,000 if we compare in the USD equivalent. So this is not the car that could cost 10,000 USD or 20,000. Of course, I wouldn't have that much money. As for the purchase of this car, I have indicated that place where my family resides is in the area of flood next to the Kremenchutska hydroelectric power station. So that's why we purchased this car, because in case of the, this specific circumstances, I could take my family in the car, get some first importance belongings, and move away. And this was not some luxury for us to buy this car. This was just as something that would be used in an emergency situation, just to rescue my family if there is a need to do so. And I would like to tell you that I did not own a single car until I turned 50 years old, even though I had a driving license as of 2004. You have explained here that one of significant sources of funds that were paid for this car was the money you got from the sale of the motorcycle. So what is the cost of this motorcycle, and how much money did you sell it for? The motorcycle was purchased a very long time ago. I can't tell you the date, but I sold it in 2019. I think I requested 28,000 hryvnias for it, and I had a buyer from Sumsky region and bought it with 25,000 hryvnias. At that time, the exchange rate of euro to hryvnia was up to 8 point something. And this money was generated thanks to the sale of this motorcycle. You also informed that for 1 year, so you managed to save up money in 1.5 years or in 2 years in order to purchase this car. But from the period as of August 2021 till July 2022, you were accrued income of 188,135 hryvnia. The income of your wife for the same period was about 73,600 hryvnias. And this way, the joint income earned by you and your wife from 2020 to July 2022 was about 261,740 hryvnia. In that period, from August 2020 to July 2022, the minimum subsistence level for a family of 2 employable persons and 2 minor children was 276,828 hryvnia. How did you manage to save money to purchase a car when your family's income was not enough even to reach a minimum subsistence level? Well, as for your calculations, I cannot make any remarks, but I would like to draw your attention. This is based on the official information. Well, it was enough for us of this since our family didn't go to restaurants. We lead a very modest way of life. So with certain limitations, we managed to save something, and I have provided the copies of the credit agreements, loans. We purchased all equipment taking loans from the bank. I mean, all the equipment like a TV set, the washing machine, we paid their price for like 1 year, 2 years, and this way we managed to save up. So I don't think there is something supernatural here. Most Ukrainians leave having a lot less money than that. I see. In the Unified State Register of Declarations, there are your declarations for 2022 and 2023. Notably, in 2023, you submitted 2 declarations as a candidate for the position of judge of the CCU. For what purpose did you submit your declaration of a candidate twice within this competitive selection? I explain myself. First declaration for 2023 was submitted by me without considering all mandatory information to be noted there, because so I wanted to avoid the situation where the AGE would think that I intentionally did not omit mentioning some data. I submitted a follow-up declaration with more details on the cost of the house, and where I also indicated the income of my wife, and I added the rights for some of the property. In section of these declarations titled Banking and Other Financial Institutions, you should have specified bank accounts, in theory, if you have some savings in the bank accounts. But you did not provide such data. So the question is, how do you get your pension payments, and how does your wife receive financial support? For the moment of filling out the declaration, I was not aware that I also had to specify the bank accounts to which these payments are transferred. I think at the moment of filling in the declaration, my understanding was that I had to specify bank accounts where I have like deposit accounts or some property rights that are not related to payments. And that's why I have indicated this information afterwards to the AGEs that I have two cards, and one is for pension and another one is credit card with certain limit. My wife also has two bank accounts. One of them where she has her social support, and another one is the where she gets rent for the land plots that she has inherited from her mother, and no other like deposit accounts in foreign currency or in the foreign banks we do not have. And my last question: you have submitted the motivational letter willing to participate in the competition for the position of the judge of the CCU. Were you interested in the constitutional law before this, or maybe you have some scientific papers or some publications concerning the subject matter that would convince us that you can be this judge? And second, you said that you wanted to get experience of participation in preparation to interviews and other procedures which are envisaged by the competition. So my impression is that us, as the AGE, provided you the free legal aid to prepare you for the future, not to make those mistakes that we already talked about today. I mean, in your declarations. Can I answer? Yes. I have sent to AGE 5 or 10 procedural documents, cassation complaints, and there I showed examples where in each procedural document I specify either, I make references either to norms of the Constitution as the norms of the direct act or the decision of the CCU, which are also mandatory for enforcement on the territory of Ukraine for... Thank you for your answer. That's all from me. Dear colleagues, are there any other questions for the candidate? If there are no questions, then Ruslan Valerievich, you may make your final remarks up to 5 minutes. Fortunately or unfortunately, no houses, no apartments, no land plots I was given by my relatives or was gifted by my relatives. Everything I own is something that I managed to get myself, being motivated by my family, my wife, and my children. My zodiac sign is Capricorn, and that means a workaholic who achieves everything with their own efforts, having ambitious goals in mind. I learn very fast. In each position, I try to be, if not one of the best ones, then at least the best. In some of the positions, I managed to do so. No, I do not have the scientific degree. No, I do not have my practical experience of the judge, but I have a sufficient life experience and 15-year experience as the practical lawyer. Judges are practitioners and lawyers are analysts in their majority. If to compare the work, fulfilling the duties by the judge of the CCU, that's also the analyst's work. Their work lies in a comparative analysis. They compare laws, norms, regulations to be in line with the norms of the Constitution and give a scientific and practical reasoning to it. So if one treats their duties fairly, if to organize the work properly, both of oneself and of the consultants and the assistant of the judge, then you can prepare materials efficiently, fast, to be considered by both the Senate and the Great Chamber. So I think if the person is experienced and if they know how to analyze the situation, the norms and regulations, then there shouldn't be any issues. I would also like to draw your attention that by the Office of the President, the Office of the President has announced the strategy for development of the system of justice and the CCU activity for 2024-2029 that envisages significant reforms both of the Supreme Court and the CCU. In the opinion of the authors of the strategy, the Constitution Court has to become transparent, fair, and integral. Apart from that, 56 People's Deputy, the Representative Tymoshenko Yulia Volodymyrovna, on the 20th of December 2024, submitted the application to the CCU where they specify that the people of Ukraine are the owner of the sovereign right to choose their own bodies of government, judicial bodies, and the judges to the CCU. It will be a difficult task for the CCU to answer whether participation in the certain selection processes, participations of the foreign representatives is a threat to the sovereignty, or that it could have the signs of the external management in the state or governance in the state, or is it recognized as the support and assistance of the foreign experts to build up democracy in our state with the principles of the rule of law. Also, I hope that the war will be over and we will have the elections for the president, local elections to Verkhovna Rada of Ukraine. Some political forces may be using means of amendments to the constitution or the electoral legislation in order to achieve their political goals. These will be powerful challenges for the CCU. During 2024-2025, it is planned to select and appoint almost half of the composition of the CCU. In my opinion, this will be fresh blood that will be able to strengthen the Constitutional Court of Ukraine and to reboot it. I want to be one of them by our joint work to leave the trace in the protection of the Ukrainian statehood. I know that all these questions of the AG is not you being meticulous, but this is your way to show the dark spots in the life of the candidate, so that nobody would have grounds in the future to affect the adoption of the legal decisions by the judge. I would like to thank the entire team of the AGE. I wish you force and inspiration to complete your work and to make your contribution in the reboot of the CCU of Ukraine. CCU. Thank you for your attention. That's all from me for today. Thank you, Ruslan Valerievich, for your answers. Dear colleagues and the public, at this point, I announce the interview with the candidate for the position of the CCU Mylovanov Ruslan Valerievich completed.